All right, Mr. Bellinfante, tell me about your motion, please.
Thank you, Your Honor. Josh Bellinfante with Robbins Firm. With me is Alex Denton on behalf of Premium Funding Solutions. Our motion is straightforward. What we seek today is an order to compel payment of rent into the registry of the court. This is not about eviction. This is not about possession, conspiracies, or even the task force. What it is about is whether Code Section 44-7-54 means what it says when it says that if the issue cannot be decided in 2 weeks from service, rent shall be required to be paid. That's all we're here for. And it's my understanding from reading the briefs, and in fact even reading the August 11 motion for reconsideration filed by the task force, that that is not in dispute. There is in dispute the question of whether we are entitled to bring a dispossessory action, and that's their motion. But the issue of rent is not in dispute in terms of what the statutes say and whether we would be entitled for it to go into the registry of the court. So the arguments they raise then deal with this law of the case issue from the Supreme Court and the plea of abatement issue. But as we...
So they're separate and distinct?
The issues between the two cases, the appealed cases and this one, we believe it is, yes, Your Honor.
All right, so they're making an argument of plea of abatement, right?
Correct.
And they're traveling under the language of the Supreme Court's order.
I've actually got a notebook, Your Honor, that has it in it if you would
May I see it, please?
Yes. Thank you. I believe the Supreme Court's order is tab 3 in your notebook.
Found the Supreme Court's order to be interesting, where it says, as for the merits of the emergency motion, we note that the task force appears to have an adequate remedy at law as against the dispossessory proceedings commenced by premium funding. In similar circumstances, very interesting use of words, in similar circumstances, the Court of Appeals has held that a plea and abatement under OCGA section 9-2-44A will lie against dispossessory proceedings commenced while other litigation is pending between the same parties in which substantially the same questions of Title II and possession of the same land are presented. And it cites two cases. At least at this point, the task force has made no showing that a plea and abatement would be an inadequate remedy at law. For that reason, we deny the emergency motion for now without prejudice. If the task force can show the absence of an adequate remedy at law, it may renew its emergency motion. How much is the monthly rent that you're seeking?
Well, Your Honor, we have attempted to work with the task force to try to determine an amount. We were unable to do so.
What was the amounts owed under the notes that were foreclosed on?
The notes provided that there was the amount total was about $900,000, thereabouts. I'm not quoting you.
What did it say? Did it have a monthly payment?
The forbearance agreements, which were the last operative agreements, did not. They had an amount that was to be due at a certain time, and then it referred back to payments.
And so y'all tried to negotiate an amount?
We did. The last that occurred was by email from me yesterday at about 11:28. We offered a number. I was hesitant to put it into the pleadings because I didn't want to violate.
What is the number you think is appropriate?
Well, Your Honor, what we did in that calculation is we looked at what the task force said the property was worth, which in their pleadings, I think it's paragraph 18 in the third amended complaints, about $4.5 million. Take the $4.5 million divided by 10. Which is the standard to determine a rate of lease. That's $450,000 a year. You divide that, that's about $36,000 a year. A month, and that works out to be about 2.6.
Have you offered to pay any rent?
We have not, Your Honor, and we would object to counsel putting in. I've asked the court if this was going to be an evidentiary hearing. The court's notice said it was going to be oral arguments. I did not ever get a response to a couple of emails that I sent. Nobody has brought in experts to testify as to rent. Mr. Bellinfante has no ability to testify to rent in this case. It would be entirely inappropriate.
Why can't they have an order requiring rent under the code section?
They cannot, Your Honor, because the code, this case is defective. All 7 justices of the Supreme Court said that if this involves possession, if the dispossessory case that they're filing involves
All
possession,
right, well, let's say I agree with you and decide that the plea of abatement applies and prevents them from dispossessing you. There's nothing in that that would prevent me from ordering you to pay rent.
there is 100%, Your Honor.
How's that?
The rent that they are asking for is a function of there being an active and alive dispossessory case. It is within the dispossessory statute. You have to file a valid, live dispossessory case for the court to have any ability or any jurisdiction to assess rent. They made their bed, they filed a case that was defective. The Supreme Court, every single justice of the Supreme Court concurred and said in these circumstances, as Your Honor just read, we don't even have to give them emergency relief because they have an adequate remedy at law. And therefore, the case is no good, therefore the court is without any jurisdiction to impose rent.
If I entered an order for you to pay rent, and then subsequently entered an order on your plea and abatement, then they have a valid order to get rent.
No, sir, they do not, because once you enter the order in my plea and abatement, it amounts to a dismissal of their case.
No,
Yes,
it amounts to a stay.
I disagree with that, Your Honor. I see no authority for that whatever. A plea and abatement ends the case, Your Honor. It is specifically designed, and if you look in the cases that the Supreme Court has cited to, it is specifically designed to prevent a party from being harassed by two active lawsuits. Stay is still a lawsuit pending. And if you go in and impose and hit us with the remedy of a case that the Supreme Court has told us has no validity, that has to be error. It has to be error.
What is your response?
Every time they've sent you to do this, it has been error, Your Honor.
What is your response?
Your Honor, I think at this point, the issue is now decided. Mr. Hall just said the only way we would have jurisdiction to have any type of dispossessory or rent paid into the court is if we filed through the dispossessory process. Your Honor said that in the August 8th letter. The Court of Appeals in 2005, in a case cited in our brief, Bendy Brothers versus Patel, said that if the applicant cannot, because of a jurisdictional bar, seek the same remedy in one case as the other in a plea and abatement case, and that was a dispossessory case, then the plea of abatement does not apply. It is an exception. Now, we maintain that if they don't meet the qualifications for a plea of abatement, the issues are distinct. The Perimeter Mall case we cited from 1977 says the issue of rent as damages is distinct from the issue of possession. And so in that way, they're not the same issues. But the court in Bendy Brothers said, even if they are the same issues, there is an exception to the rule, and that exception is if the court's jurisdiction cannot be exercised. We have said that. The Court of Appeals said that when this case was last there, that the exclusive method for seeking dispossessory is through the dispossessory statutes, and Mr. Hall has now said the exact same thing. Under the binding precedent of Bendy Brothers.
What is the site of that case?
It is 275 Georgia Appeals 143.
Your Honor, he's mistreated what I said, and he's also absolutely distorted the Bendy case. It is completely factually distinct, and it's inopposite. Let me explain why. First of all, what I said was not that the only way the court could ever have imposed rent would be through a dispossessory action. That's an intentional mistreatment of what I said. What I said is if you want to impose rent under the dispossessory statutes, which is the only thing they've asked for, that you must have an active dispossessory case.
Can I impose rent with the equity powers of this court?
No, you cannot, because when I took what the Supreme Court ruled is that when you dissolve the injunction against them bringing this case and allow them to bring the case, the Supreme Court ruled that gave me a direct appeal up to the Supreme Court that has deprived this court of jurisdiction to modify, clarify, alter, change, abrogate that injunction. We are frozen where we are. And we are frozen specifically because of what PFS did. They made their bed. Now, Your Honor, let me tell you about the Bendy case, because they are completely distorting the Bendy case. The Bendy case involved this question. If a party brings a lawsuit in a situation where they cannot get jurisdiction to hear one of the claims, they bring it in a state court where there's an equitable court, where there's
Wait a minute, they dismissed your application for direct appeal.
No. They dismissed my application for interlocutory appeal because they said that I had a direct appeal in the first paragraph. Let me flip to it, Your Honor, and I'll point you right there to where it is. What it said is, if you go to the second, I'm sorry. The task force has attached a notice of direct appeal, this is the bottom of the first paragraph, which appears to have been timely filed in the trial court to its application. The application is therefore duplicative, and for that reason it is dismissed. So what happened, Your Honor, was this was a dissolution of an injunction. That is a direct right of appeal up to the Supreme Court. This court is divested of jurisdiction to alter the injunction status. This is the bed that PFS put it in. I objected so strenuously, Your Honor, and pleaded with the court to put all of this in one case. And they decided they thought they could get a procedural advantage, keep evidence away from the court, if they filed this, and they put themselves in a box. And they put
So it's your contention that the dissolution of the interlocutory injunction is presently on a direct appeal to the Supreme Court?
It's the Supreme Court's statement to me, Your Honor, and it is my contention.
And Your Honor, they sought relief to do exactly what they're claiming has already been done. That was the basis of the emergency motion. The Supreme Court denied the emergency motion, and so that's why we're here on a motion to dismiss and motion for judgment on the pleadings with the issue of plea of abatement.
Your Honor, that is either a complete lack of understanding of appellate practice or an intentional distortion. The Supreme Court's order, which you just read, made it dead clear. It said, and we all know this, any of us who have practiced appellate law know this, that the courts of appeals don't rule on an issue that they don't have to reach. And what the Supreme Court told us here is, we don't have to rule on Mr. Hall's emergency motion because he's got a plea in abatement that is an answer at law. They invited us to bring it. They cited him to the cases that say it applies. And in fact, many of the arguments that he's making in his brief, if he had taken the time to read the cases that the Supreme Court cited him to, he would have realized that the Court of Appeals has already held those arguments to be spurious.
Well, but here's my point. I think you're entitled to an order for rent. But here's my concern. My concern is you can't get the rent unless and until you file the dispossessory. And you can't file the dispossessory but for the dissolution of the interlocutory injunction. They appealed the dissolution of the interlocutory injunction, and they're claiming that issue's on appeal. So if I was wrong to dissolve the injunction, then you couldn't file a dispossessory. So I think you're entitled to an order for rent, but I don't think I have jurisdiction to give you that order if this issue's up on appeal. Does that make sense?
It would, but for the fact that the dispossessory was filed first. There has been no order in that separate case. And, I mean, we can go back and forth over what the Supreme Court's order said. But what it says at best, and it's not even this, is dicta. There's no kind of holding in this one paragraph order. And so the jurisdictional issue would be for what's going on in the appealed cases. This case was filed first, or before the notice of appeal was submitted to the Supreme Court. The Supreme Court had the opportunity to decide that everything should be frozen. It did not, and it said that the procedure that should follow is you look to a plea and abatement. We submit to you the issue, and the task force is
You're saying the two separate issues, rent and the dispossessory.
Well, that and they're two separate issues. They're trying to say, one, there's some type of freeze and you lack jurisdiction. Then they're conflating that with a plea of abatement, which is what the Supreme Court said.
But you say the rent and that are separate issues, because the plea of abatement would have to do with possession, which is being litigated in the case in chief.
And I'm prepared to explain that, Your Honor. It is a complete distortion. Mr. Belafonte may not have anything at stake if you violate, if he causes you to, this court to violate the Supreme Court's order that all 7 justices have signed on. He may try to tell you this is dicta when they've laid out something that is clear as day to all of us. All he's going to do is put us all down another path, yet again, like they have again, to an error. This is why they can't get rent. They cannot bring a claim for dispossessory. The Supreme Court has said you can't do it if the issue of possession is already in place in another case. It's in place from Ichthus's first complaint, it's in place from my counterclaim, it's in place from my claim against PFS, it's in place from PFS's claim against me. 4 times.
All right, let me go look at something, I'll be back.
Okay, thank you.
All right, please be seated. On the notes that were bought from the church, what was the mortgage payment for the property before you got to the forbearance agreement?
I don't have that information in front of me. I know there's folks here who could probably answer that. I don't have it.
You know what it was, Mr. Hall?
I do not off the top of my head, Your Honor.
All right, the Supreme Court recognized that you filed a notice of appeal, but there hasn't been one docketed in their court with regard to the dissolution of the interlocutory injunction.
Your Honor, it is the notice of appeal, not the docketing.
I understand that.
And in addition, the defendants have all filed cross appeals. Everybody has taken everything on this, in this case, up to the Supreme Court, and it is all there. And this court is absolutely enjoined from going forward and changing any of its current orders on summary judgment, injunction, anything like that. It would be a straight violation.
Did all of the defendants file cross appeal?
PFS certainly did, ADID did, CAT did. I don't know if Ichthus did or not, but they filed a cross appeal and an amended cross appeal.
We did, Your Honor, and I will say this. We are not asking you, we're not even here on the appeal lawsuit. We're not asking you to exercise jurisdiction. We're asking you to do what Mr. Hall just said. Don't disturb the orders that are already on appeal, including the one.
Well, there's nothing affecting the dispossessory at this point.
Yes, there is, Your Honor.
What is that?
The dispossessory is that the Supreme Court has told us that there is a defense in abatement. I have brought the defense in abatement. I have raised it. The case law, and it is Beddingfield versus Beddingfield, 248 Georgia, 91, and it says an abatement is a dismissal, results in a dismissal. So there cannot be rent imposed under the dispossessory statutes. And I would suggest, Your Honor, that if the court were inclined to manufacture a way to try to contort what I think is a dismissed claim into a way that allows us to be charged rent that the Supreme Court has indicated is not appropriate to be charged.
Now, how have they indicated that?
Because they have said we have a defense in abatement under these circumstances. And they have cited us to, Your Honor, let me read to you the case they cited just to. If you look at the Schoen case, what it says is the plea in abatement has been held good even where the causes of action are technically speaking legally disparate and rest in opposite parties. If they arise out of the same transaction and if the second suit would resolve the same issues as the first pending suit and would therefore be unnecessary. The first suit, I'm seeking to retain possession, clear title. The second suit, they're trying to take possession. It will be resolved by my case. Now, they're going to try and tell you this is somehow a different claim, rent is disparate, is different. The full panel of the Court of Appeals called those kind of arguments specious in this case. What does it mean if they're making arguments that the full panel has already told them are specious? This court cannot be led down that path. It just simply cannot. This is their bed. They made it because they were trying to pull a fast one, Your Honor. They wanted to get themselves into a proceeding where they didn't have to discuss all the bad stuff that they had done. And by trying to pull a fast one, they got themselves stuck and put them here, and they did it over my objection, Your Honor.
Here's what I want to do. Yes, go ahead.
I just want to respond briefly on a couple of points. One, the Schoen case from 1980 is postdated by Bendy Brothers, so the arguments are distinct. Two,
Where's the Bendy Brothers case?
that's in 2003, I believe, is Bendy Brothers.
I have a copy of it, Your
May
Honor.
I see it, please?
I have a copy of it for you, Your Honor.
And what we have, and here's the problem.
So,
in the counterclaim from PFS, PFS did not seek possession. What it sought was leave. That's paragraph 61 of its counterclaim. It sought leave to file this possession. It sought rent as damages. In this case, in this dispossessory case, we're not seeking any damages, we're seeking dispossession. Now, Mr. Hall can make all of his arguments. He can have his trial on quiet title and wrongful foreclosure if the appellate courts decide that they're going to reverse their most recent holdings on that issue, and by most recent I mean basically in the past century. But if that's the case, they still, under the dispossessory laws, have to pay rent into the registry of the court. That's the only issue here. It's not about whether they can make the arguments or not. But the claims were not made in the appealed lawsuits. The claims under Bendy Brothers, it says, and there was no jurisdiction to bring them in a case, brought under the Civil Practice Act, which was their case, in a counterclaim brought under the Civil Practice Act, which is their case, because the Court of Appeals told us the only way you can have a dispossessory warrant is going through the dispossessory statutes, which is what we did. And beyond that, beyond the fact that the Court of Appeals has already said that, this court said that in the August 8th order, which is we have been granted leave to file a dispossessory action in the Superior Court of Fulton County. That's what we did.
Here's what I'm
May I say
inclined.
this? Count two of their complaint in this case is for rent. So he's trying to tell you that he's not asking for the same thing in the dispossessory proceeding. He's saying things that are false to you in the same sentence, Your Honor.
That's
He is
just not
asking
true.
for rent. I can bring Your Honor a
But that's
copy.
in the original
It is in
suit.
his original suit, it is count two for rent.
Right.
And now he's trying to tell you, I also want rent in the dispo.
Here's what I am inclined to do. I'm inclined to reset this, let Mr. Belenfante put up evidence of what fair market rent would be. I'm inclined to grant that rent, stay that order, give you a certificate of immediate review, and grant the plea of abatement with regard to the dispossessory. And then it can all be up there in one neat little package.
Your Honor, I think it is error not to grant the plea in abatement, and I think it is error to assess any rent, and I think it is error to.
I'm telling you that I'm inclined to grant the plea in abatement, but I want more time to research these cases, but I'm also going to give you an opportunity to bring me a witness. So can you do it in 2 weeks?
Yes, Your Honor.
Your Honor, that will require me to engage an expert, I believe, on rent. It will cost my client thousands of dollars to get that done. I think it is entirely inappropriate.
Well,
to
why
do
don't
that.
we agree on a certain party that the Mr. Belenfante's client will pay? I think that you get somebody competent in downtown real estate, and you just agree on it.
Quite frankly, Your Honor, I am not prepared to agree to an independent party to do that at all.
Why is that?
Because every single time that we try to approach this in my mind is a very straightforward case, Your Honor. It all ought to be set down, it all ought to be tried.
I'm trying.
I can't stop what the court is going to order on what it's going to order, but I'm going to make my objection, which is if there's going to be an issue over rent, I want to be able to put up evidence on rent, and I think it causes me great harm if the court is going to ignore the abatement plea
All right, here's what I wanna
until I
do.
go through that.
Here's what I want to do. Submit to the court and to the other side a curriculum vitae of whoever it is you contemplate using. I'll enter an order of what I'm going to do no later than Friday. I'll put this down for 2 weeks from today at 2 o'clock. Okay?
Your Honor, thank you, Your Honor. We are going to file a motion with the Supreme Court and take an appeal of this, Your Honor.
I haven't done anything for you to appeal.
Well, you've indicated what you're going to do, that you're going to set it down, that we have to do this, and I think I need, Your Honor, a decision on whether or not you're going to grant my plea in abatement or not. Is what I think I need, because I've got to perfect my record with all due respect. I've got to perfect my record.
All right,
and
well,
I
submit
need
me an
more.
order granting your plea in abatement.
Okay.
Well, Your
Thank you,
Honor, if you do that.
All right, that's right, that's right,
Yes,
that's right. There's
yes.
nothing to appeal until I enter an order next Friday.
Correct.
There's nothing to appeal until I enter an order next Friday. And if you want time to appeal that, let's go 3 weeks out.
Your Honor, I believe that I am entitled to a ruling on the abatement issue before we set rent. And I believe that is appealable, and I think the court has an obligation to give me a ruling on the order that I've asked for before we end up having to go in and deal with rent.
Your Honor, if I may, I think the court, and I know there's orders on this because we've been on the other side of it, the court has broad discretion in deciding when it is going to enter orders and at what time it's going to do so. I don't think that discretion.
Well, let's say I entered an order for rent before I entered the order on the plea and abatement. I already told you I was gonna stay the order pending appeal.
Your Honor, I do not think that is appropriate, and I think what.
But I hadn't decided what I'm gonna do.
Well,
I
Your Honor,
read the Supreme Court opinion over and over again, and I've looked at the docket, and just give me till next Friday to do something.
Your Honor, I can't stop what the court is going to do. I believe that I'm entitled to a ruling on this, and I believe I'm entitled to something that either abates the case or says the court is not going to abate it, in which case I'm going up to the Supreme Court on it.
And is the plea of abatement a directly appealable issue?
You know, Your Honor, I haven't even looked at it, but I would believe so because it brings the dispossessory case to a finality, and then they could take it up and appeal to the
All
Supreme
right,
Court.
what is 3 weeks from today? Does anybody know?
Your Honor, I don't know.
If I could check.
October 2nd, Your Honor.
October 2nd, 2 p.m. I will have a ruling with regard to everything else by next Friday. Okay, Friday, which is, today is the 11th, tomorrow's the 12th, Friday will be the 19th. Okay?
I'm sorry, Your Honor, what are you ruling on
I'm
Friday?
gonna rule one way or the other on the abatement and the rent. Okay? I wanna research it some more.
And then October the 2nd, is that the date?
That would be a hearing on the rent if we have it.
Thank you,
Okay.
Your Honor.
All right. That'll give everybody time to appeal, but there's nothing to appeal at this moment.
That's right.
All right, y'all have a good day.
Thank you, Your Honor, you as well.
See you on the calendar over with.